Hi, my name is Tony, and today we're going to talk about Part C and D, Enrollee Grievances, Organization Coverage Determinations, and Appeals Guidance. Welcome to our guide on Medicare appeals and grievances. We will be addressing grievances, coverage organization determinations, and appeals for beneficiaries enrolled in a plan provided by either a Medicare Advantage organization, a Medicare cost plan, healthcare prepayment plan, or a standalone Part D plan. This document is intended to provide clarity regarding existing requirements under the law. It does not have the force and effect of law unless specifically incorporated into a contract. Understanding the appeal and grievance process is crucial for beneficiaries to ensure they receive the healthcare services and benefits they are entitled to. If you have any questions or need further assistance, please visit the CMS web pages or contact your plan representatives. Now let's go over terms used in this guidance and see what these commonly seen terms mean. Appeal. The procedure that deals with the review of adverse initial determinations made by the plan on healthcare services or benefits under Part C or D. The procedures that deal with the review of adverse initial determinations made by the plan on healthcare services or benefits under Part C or D the enrollee believes he or she is entitled to receive, including a delay in providing, arranging for, or approving the healthcare services or drug coverage. Beneficiary and Family-Centered Care Quality Improvement Organization, also known as BFCCQIO. These organizations comprise of practicing doctors and other healthcare experts under contract to the federal government to monitor and improve the care given to Medicare enrollees. The BFCCQIOs review enrollee complaints about the quality of care provided by physicians, inpatient hospitals, hospital outpatient departments, hospital emergency rooms, skilled nursing facilities, also known as SNFs, home health agencies, and Medicare managed care plans. Clean claim, Part C only. A claim that has no defect, lack of any required documentation, or particular circumstance requiring special treatment that prevents timely payment and that otherwise conforms to the clean claim requirements for equivalent claims under original Medicare. Dismissal. Dismissal is a decision not to review a request for a grievance, initial determination, or appeal because it is considered invalid or does not otherwise meet Medicare Advantage or Part D requirements. Effectuation. Authorization or provision of a benefit that a plan has approved, payment of a claim, or compliance with a complete or partial reversal of a plan's original adverse determination. An eligible individual who has elected a Medicare Advantage prescription drug or cost plan or a healthcare prepayment plan. Grievance. An expression of dissatisfaction with any aspect of the operations, activities, or behavior of a plan or its delegated entity in the provision of healthcare items, services, or prescription drugs. Independent Review Entity, IRE. An independent entity contracted by CMS to review adverse level 1 appeal decisions made by the plan. Inquiry. Any verbal or written request for information to a plan or its delegated entity that does not express dissatisfaction or invoke a plan's grievance, coverage, or appeals process, and such as a routine question about a benefit. Non-contract provider. A provider or supplier that does not contract with MA organization to provide services covered by the MA plan. Quality of care grievance. A grievance related to whether the quality of care covered services provided by a plan or provider meets professionally recognized standards of healthcare, including whether appropriate healthcare services have been provided or have been provided in appropriate settings. Reconsideration. Under Part C, the first level in the appeals process involves a review of an adverse organization determination by an MA plan, the evidence and findings upon which it is based, and any other evidence submitted by a party to the organization determination, the MA plan, or CMS. Under Part D, the second level in the appeals process involves a review of an adverse coverage determination by any independent review entity, the evidence and findings upon which it is based, and any other evidence the enrollee submits or the IRE obtains. Redetermination. The first level in the Part D appeals process involving a review of the adverse Part D coverage determination by the plan sponsor, including the findings upon which the decision was based and any other evidence submitted or obtained. Reopening. A remedial action taken to change a binding determination or decision even though the determination or decision may have been correct at the time it was made based on the evidence of record. Representative, an individual appointed by an enrollee or other party authorized under state or other applicable law to act on behalf of an enrollee or other party involved in grievance, organization determination, or appeal. We're going to test our knowledge now. First question. Imagine you are a Medicare beneficiary who has received an adverse coverage determination from your Medicare Advantage plan. You decide to appeal the decision. Which of the following steps correctly outlines the appeal process for both Part C and Part D? Options: A. Reconsideration, B. Redetermination, C. Independent Review Entity IRE, or D. A and B, which are reconsideration and redetermination. I'll give you guys a second. D, A and B, reconsideration and redetermination, you are correct. Second question. An independent entity contracted by CMS to review adverse level 1 appeal decisions made by the plan. Options: A. International Review Entity IRE, B. NCQA, C. Independent Review Entity IRE, or D. Bruins. If you're an independent review entity, you are correct. Moving on to applicability to employer-sponsored benefits. Managed care appeals procedures apply to all benefits under an MA plan, including optional supplemental benefits. Employer purchased benefits, examples are premiums, enrollee cost sharing, are not subject to these requirements. Claims processing and appeals for Medicare cost plans and HCPPs. Claims processing. Part B claims. MACs process claims for enrollees in cost plans as regular Part B claims. Example, out-of-network physician visits, or physical therapy visits. Part A claims. MACs process claims for enrollees in cost plans as regular Part A claims. Example, out-of-network facility use or home health services. Appeals. Appeals for services received through the cost plans network or directed out of network are subject to cost plan rules. Enrollees cannot be held liable for Part A or Part B services if a MAC denies the claim. Fee-for-service appeals rules applies to first-level appeals in cases of self-referral out of the cost plans network. Procedure: handling incorrectly filed appeals. If an appeal should be filed with the MAC, the cost plan must inform the enrollee and direct them to the Medicare summary notice for the fee-for-service appeals process. The evidence of coverage must inform enrollees that cost plan's appeal process is only for disputes related to organization determinations or certain emergency admissions. Medical exigency standard. Plans and independent review entities must make decisions as quickly as the enrollee's health condition requires. Apply established medical practice standards to assess the individual's condition using evidence from the treating provider or medical records. Develop standards to determine the urgency of coverage requests, triage incoming requests, and prioritize each request appropriately. Do not routinely take the maximum time permitted for the coverage requests. Role of the medical director. Plans must employ a medical director responsible for ensuring the clinical accuracy of all coverage decisions involving medical necessity. The medical director oversees clinical decision-making, including medical and utilization review, benefits and claims management, formulary administration, processing coverage decisions, provider-prescriber outreach, staff training, and oversight of delegated entities. The medical director must be a licensed physician as defined in the practicing state. Knowledge again. Who has the overall responsibility of making the final clinical decision for cases? Options: A. The RN. B. Any physician part of the health plan. C. The medical director for the health plan. D. Joe Bruin, the nurse practitioner for UCLA. Yeah, medical director of the specific health plan, you are correct. Delegation of responsibilities. Plans may delegate responsibilities to entities or individuals providing Part C or Part D benefits, except for the employment of the medical director. Plans remain responsible for ensuring delegated entities meet CMS requirements. Comprehensive monitoring and auditing processes must be in place to validate compliance. Communication to enrollees. Establish procedures for standard and expedited initial determination appeals and grievances. Provide written information about these procedures at initial enrollment upon request, annually, and during specific circumstances. Example, involuntary disenrollment, changes to procedures, adverse determinations. Ensure all written communications are understandable and use appropriate notice language. Provide communication in alternate formats and languages. Ensure fax, email, and web-based portal systems meet HIPAA privacy and security requirements. Enrollees requesting alternate formats should have the same level of access to information. Account for additional time needed to provide instructions in alternate formats for timely submission of claims. Ensure enrollees with limited English proficiency have equitable process access to plan representatives and information. Again, the plan communication to an enrollee, making sure enrollees that are requesting alternate formats have the same level of access to information, accounting for additional time needed to provide instructions in alternate formats for timely submission of claims, ensuring enrollees with limited English proficiency have equitable access to plan representatives and information. Of days for assessing plan timeliness. Day 1 is the day after the plan receives the request. Timeframes are measured in calendar days, including weekend and holidays. An example, MA plan receives a request on May 1st. Determination must be made by May 15th. Part D plans receive a request on May 1st at 10:30 a.m. Determination must be made by May 2nd at 10:30 a.m., a 24-hour turnaround time. Request is considered received by the plan. Requests are deemed received based on date and time stamped by regular mail, delivery by a trackable service, example UPS or FedEx, successful fax transmission, verbal request via phone, voicemail message, submission through the plan's website. Processing timeframe begins when the plan or delegated entity receives the request. Ensure requests are routed to the correct location promptly. When a notification is considered delivered by the plan. Written notification is considered delivered when deposited into an external mail sent electronically. Verbal notification is considered delivered when spoken directly to or voicemail left for the enrollee. Written notification must follow verbal notice within 3 calendar days. A verbal notice fails, written notice must be sent within the applicable time frame. For Part C reconsiderations, determinations must be issued within 30 calendar days. Outreach for additional information to support coverage decisions. Plans must have processes to make timely coverage decisions, including soliciting clinical documentation when necessary. If insufficient information is available, plans should make reasonable efforts to obtain necessary details. Outreach to providers is required only if additional information is needed for coverage or appeal decisions. A minimum of one attempt to obtain information is sufficient, but best practices include multiple attempts and multiple methods of, for example, phone, fax, and email. For Part C only, expedited organization determination and reconsideration requests, MA plans must request necessary medical information from non-contract providers within 24 hours of their initial receipt. Filing on behalf of enrollees. Representatives can be appointed or authorized to act on behalf of the enrollee for grievances, initial determinations, or appeals. Who can act as a representative? They can be appointed by an enrollee, for example, a relative, a friend, advocate, or an attorney. It requires Form CMS 1696 or a equivalent written notice, or it can be authorized by law. For example, someone can be a court-appointed guardian, or a durable power of attorney, healthcare proxy, or executor of an estate. It requires legal papers supporting status. Of representative AOR form or equivalent written notification. Plans must accept a Form CMS 1696 the AOR form or equivalent written notice. Electronic signatures are accepted if submitted through secure means. Equivalent written notice must include the name, address, and phone numbers of enrollee and the representative. Enrollee's HICN, MBI, or plan ID number. Representative's professional status or relationship, explanation of purpose and scope of representation, authorization statements and acceptance by representative, signed and dated by both enrollee and the representative. The valid representative form, valid for 1 year from the date signed by both parties unless it is revoked, valid for the life of the grievance, coverage request, or appeal if received within 1 year of signing. No need to refill a photocopy for future requests if the form is maintained and accessible by the plan. Separate forms required for MA and Part D benefits if specifically limited. Effective representative forms. If a request is filed by a person claiming to be a representative without a valid document, the plan should do the following: develop procedures to avoid delays for expedited requests, inform the enrollee and representative in writing that the request is not valid until documentation is provided, make reasonable efforts to secure the necessary documentation. The plan must also not issue a decision until documentation is obtained. The timeframe for acting begins when the documentation is received. If documentation is not received within the applicable timeframe, then it moves on to dismissal. The request is dismissed and a written notice is sent to the enrollee and the representative, explaining the reason, the rights to vacate the dismissal, and how to cure the invalid requests. MA and Part D plans are not required to process the grievances without proper representative documentation. They need to notify the enrollee and the representative if the grievance cannot be processed due to missing documentation, providing or including instructions on resubmitting the grievance. Testing our knowledge. True or false? AORs with electronic signatures must be accepted if submitted securely. Options A, true, B, false, C, it's a trick question. If you answered A, correct, they can be accepted. Thanks. Thank you guys for watching. That concludes part 1. Stay tuned for more information.
Have you ever wanted to make a complaint when you were not satisfied with some sort of services you received? Well, in Section 30, we will discuss just that, grievances, how they are filed and handled. All right, we're going to talk about grievances. And what are grievances, you ask? It is a dissatisfaction with any aspect of the operations, activities, or behavior of a plan or its delegated entity, and it's available to enrollees or their representatives. We're going to be talking about classifications, and it's going to be important to be able to classify any requests that come through in the appropriate category to avoid an error, because once an error is discovered, we would then have to reclassify them in the appropriate category, but we are still held to the appropriate timeframes. So the 4 different categories that we can classify these requests are going to be either grievances, inquiries, coverage requests, or appeals. And again, grievances are complaints or an expression of dissatisfaction with any aspect of the operation, activities, or behavior of a plan or its delegated entity. Inquiries are confirmation of services or benefits. Coverage requests are basically requests made to cover certain items, services, or requests for continuity of care. Appeals are a reconsideration or redetermination of an initial adverse decision. Grievances can be requested in writing or verbally. They are handled in the same way, where members or their representatives must file the grievance within 60 days of the incidents occurring. However, if the request is filed after the 60 days, a plan may still accept to investigate the grievance, but is not required. The timeframes for grievance requests follow the same rules for both verbal and written. Standard requests are to be processed within 30 days and 24 hours for expedited. A 14-day extension, however, may be granted if the health plan documents that the extension is in the best interest of the member. The difference between a written and verbal grievance request is that verbal grievances may be resolved within the same time that it is requested. An example to this situation is if a member calls to make a complaint and the situation can be resolved within that same call, then the process is considered complete, but still would require the appropriate documentation followed by proper notification requirements. Notification requirements for grievances are usually done in the same modality as it was requested. However, if requested verbally, the option of sending a written notification is also acceptable. If a member requests that a verbal resolution be provided to them, then a written notification must follow within 3 calendar days of the verbal notification. Resolutions must address all issues raised in the initial complaint. It must also be written in a way that is easy to understand for the member, such as their preferred language, and again, must be sent out within the appropriate timeframes of 30 days for standard and 24 hours for expedited. We can receive 2 types of grievance requests, clinical and non-clinical. Non-clinical grievances are those complaints regarding enrollment issues, billing, or even accessibility of contracted providers. Clinical grievances, however, focus on quality of care issues, and these types of issues can be grouped into 3 main categories. A member may raise concerns about a misdiagnosis, a treatment that they felt was not appropriate, and lastly, concerns regarding whether they had or had not received care that may have adversely impacted their health. An enrollee or their representative may request that a grievance be withdrawn at any time as long as a resolution has not been completed. The health plan must clearly document the withdrawal request and modality in which it was received, and provide a written confirmation to the member or representative within 3 calendar days of the withdrawal. It's important to also note that if a quality of care concern was initially requested but later withdrawn, the health plan must still investigate the complaint but is not required to notify the member or representative of the resolution. Now that we have reviewed the process for handling of grievances, it is time to test your knowledge. Please answer the following question. What are the 4 classifications that requests can be placed into? Is it A, B, C, or D? I'm going to give you a couple of minutes to review the options to select the right answer. The big answer reveal. If you chose option C, which are grievances, inquiries, coverage requests, and appeals, then you are correct. If you chose any of the other options, those options are incorrect because they include choices that fall within the 4 main classifications. So let's test your knowledge a little further. Please answer the following question. Resolution notification of grievances must include all of the following except A, must be notified verbally or in writing, B, addresses all issues raised, C, processed within 30 days for standard grievance and 24 hours for expedited grievance, D, must be sent to the provider, and E, must be written in an easy and understandable manner to the member. I'm going to give you a few minutes to figure out which is the best answer. And the correct answer is D, must be sent to the provider. This information is not correct because grievances must be filed by either the enrollee or member or their appointed representative. So therefore, a notification of the resolution sent to the provider would not be included as a provider is not an acceptable requester for a grievance. Next section that we're going to be discussing is section 40, which talks about initial coverage and organizational determinations. What is an initial determination? It's an initial decision by a plan or group about paying for or providing an item, service, or drug. There are 5 different categories of determinations that a health plan must render, one of which is payment for out-of-area healthcare services, and that'll include HD services when traveling, emergency services, post-stabilization of care, and urgent care needs. Next category are payments for all other healthcare services that are different from the previous category. Refusal to authorize or pay are decisions from initially denied services or items. This would include appeals. Reduction or discontinuations are determinations made to reduce or discontinue services that had been previously approved. An example to this are skilled nursing authorizations. Although previously approved, continued medical necessity reviews determines that services are no longer needed and a last approved day is therefore issued with advance notice. Failure to provide timely services are untimely decisions by a health plan, which results in an initial adverse decision and subject to an appeal. What is a prior authorization? It is a request by a person, their representative, or their provider to check if services, items, or Part B drug will be covered. So who may request an initial determination? An enrollee's representative, granted they have the proper documentations. contracted or non-contracted provider or physician, and the staff of a contracted or non-contracted provider or physician. Requests for initial determinations can be done verbally or in writing. Verbal requests must have a process for documentation and processing. However, if a plan does not accept verbal requests, then the plan must explain the procedures to file written requests. The health plan must accept all written requests and is prohibited from requiring requests to be on certain health plan derived forms. If not enough information is provided initially, the health plan must make reasonable and diligent efforts to obtain the necessary information. Expedited initial determinations. Per CMS's definition, expedited requests pertains to services and items that can seriously jeopardize the life or health of a member or the ability to regain maximum function if not reviewed quickly. The health plan must initially determine if an expedited request meets CMS's definition and approve or deny the request to expedite. If the request to expedite is denied, the health plan must promptly notify the member of the denial to expedite and advise that the request will be processed as a standard request. This can be done verbally, and a written notice must then be sent within 3 calendar days of the verbal notification. A 14-day extension is allowed if requested by a member or if the plan justifies that the extension is in the best interest of the member. So expedited requests, once received, the health plan would then either approve or deny the request to expedite, and if approved, the health plan must process the request within 72 hours for services and items or 24 hours for Part B drugs. And if the request to expedite is denied, the process is to complete the authorization request as a standard. Qualifications to review initial determinations. For requests that are anticipated to be partially or fully denied based on medical necessity, the review must be completed by a physician or other appropriate healthcare professional who has the following: sufficient medical knowledge or expertise, knowledge of the Medicare coverage criteria, and also has a current unrestricted license to practice within the scope of their profession. The box below comes straight from CMS's guide and basically states that the reviewing healthcare professional must be an expert in the specialty of the type of services that are being requested at the time of the review. Processing timeframes. The chart is a straightforward breakdown of all timeframes for services, items, Part B drug requests, along with payment claims. The health plan's failure to meet these specified timeframes allows the right for a member to file a Level 1 appeal due to an untimely decision. So for items or services, a standard request is 14 days, and with an extension, that takes it to a total of 28 days. A Part B drug standard request is 72 hours. Expedited items or services is 72 hours with an extension that goes up to 17 days. And a Part B drug request that's expedited is 24 hours. Notifications for initial determinations. Approval notifications should explain any condition to the approval, like the duration the approval is valid. Notifications must be done verbally or in writing to both the member and provider. If done verbally, a written notification must also follow within 3 calendar days. Denial notifications must be sent to both provider and member in writing, and the specifics included in a denial notification will be discussed in further detail on the next slide. Denials, discontinuations, and reductions of previously approved services have specific information and language that must be included when sent to member and provider. Denial notices must have the approved language from CMS Form 1003-NDMCP, which is also referred to as the Integrated Denial Notice or IDN. Notice must also include specific and detailed explanation of why the services, items, or Part B drug were denied, the criteria for which the decision was based on, and what information is needed to approve coverage. Additional information that must be included is members' appeal rights, the description of both standard and expedited appeal processes, and the right to submit additional information. There are special circumstances for initial determinations to consider. These are misclassifications, withdrawals, and dismissals. Misclassifications happen when a plan misclassifies a request, and the plan must immediately notify the member of the error and advise that the request will be processed appropriately and still be held to the specific timeframes. It's important to note that these timeframes remain the same regardless of when the error is discovered. Withdrawals can be initiated by the requester, whether it is the member, representative, or provider, as long as a decision has not yet been rendered. If a withdrawal is requested, either verbally or in writing, then the initial determination itself will be considered dismissed. Dismissals can happen in different scenarios, one of which a request can be dismissed if an individual or entity is not permitted to request an initial determination. A member expires while a request is still pending. The requester either verbally or in writing requests for the dismissal, or if the request itself is invalid. Now, an invalid request could be if a provider requests for an initial determination but does not provide enough information to actually create the request. And after multiple attempts to try to retrieve the appropriate information and no follow through with the provider, then we could potentially dismiss the authorization or the request because we don't have enough information to even create a full request. Dismissal notices must be in writing by applicable adjudication timeframe, and it must include all the above in the notices: the reason for dismissal, the right to request that the plan vacate the dismissal action, and the right to request review of the dismissal. Vacating a dismissal is when a plan finds good cause within 6 months of a dismissal notice being issued, such as if the plan finds it was dismissed in error. And a request for review of a dismissal can be initiated and has the same time frame as an appeal, which is 65 calendar days from the time of the dismissal notice. So for example, if the member does not agree that the case was dismissed appropriately, they can request that the dismissal be reviewed. All right, let's go ahead and test your knowledge. Please answer the following question to the scenario listed below. The health plan received a prior authorization request for a member that is in need of custom foot orthotics. The request was marked as expedited on the fax cover sheet. What is the next course of action the health plan must take? A. Determine if the request meets CMS criteria for expedited reviews and either approve or deny the request to expedite. B. Review the request as quickly as possible. Expedited reviews have a processing time frame of 72 hours from time of receipt. C. Review the request within 30 days because custom orthotics should only be reviewed as a standard request. Or D. Dismiss the authorization request because custom orthotics are not a covered benefit. If you answered A to the question, you are correct. The health plan's next course of action is to determine if the requests meet CMS criteria for expedited reviews and either approve or deny the request to expedite. Although option B is an appropriate step, it is not the first step that the health plan must take when initially getting an expedited review. Options C and D are also not appropriate because there is no criteria that indicates a specific service or item must be reviewed as standard only. And reviews may not be dismissed for reasons of not being a covered benefit. That would be determined after a review is completed. Let's test your knowledge a little further with one last question. Please answer the following question with the scenario. The health plan has determined that the prior authorization will be processed as a standard request for the custom foot orthotics and denied the request to expedite. The nurse reviewing the case previously worked at a obstetrics and gynecology clinic. After reviewing appropriate clinical criteria and benefit coverage, the nurse determines that the custom orthotics does not meet medical necessity and has seen similar requests denied. The nurse has the appropriate scope of practice to deny the request. True or false? If you chose false, then you are correct. According to CMS, if a request is expected to be denied for medical necessity, it must be reviewed by a physician or other healthcare professional with an active, current, unrestricted license to practice and has the expertise in the services being requested. Congratulations! You have reached the end of part one of CMS's C&D enrollee grievances, organization/coverage determination, and appeals training. We know it was a lot of information to take in, but hopefully it was made simple to understand. Thank you for watching.